Hey all, welcome to ShareTrekc. This is Raj here, and friends, today I want to talk to you about the Illumina lawsuit from Carl Icahn on behalf of Illumina. So it's a derivative suit, which means that he's filing this suit on behalf of the company. So let us go through those the actual document itself, because I've been able to locate the document. And I'm going to go through it. It's really revealing. So those of you who are holding Illumina shares, you should look at this petition and see, and understand what exactly is happening inside Illumina. It's very worthwhile. So without further delay, let's get started. Welcome back, friends. Today I'm going to walk you through the case that we have that has been filed in the court by Carl Icahn and his company against the board of directors of Illumina for the benefit of Illumina shareholders, and which they want to make it into a class action so that the efforts of all the petitioners is coordinated instead of being piecemeal here and there. So this particular suite has got a bunch of demands. I'll explain to you what the demands are towards the end, but let us go through that step by step. It's absolutely breathtaking what is being alleged here. So let me take you to the document first. So here we are in the document which was filed in the court. And this is in the state of Delaware, because that's where the companies are registered and that's where these actions generally take place. And you will see, first off, the first thing to note is that apart from the executives who are named as defendants, Illumina is named as nominal defendant. So nominal defendant is generally put there basically to fulfill some legal requirement. And that would be the case here. Basically, the defendants are Francis D'Souza, John Thompson, the whole set of names out here, which have been provided. These are the defendants. So that said, a defendant is an individual or entity who is being sued or accused in a legal case, typically in a civil or criminal lawsuit, and they are the party against whom the legal action is brought. The defendant is expected to respond to the claims or charges made by the plaintiff in civil cases or the prosecution in criminal cases, and this response may involve defending against the allegation, presenting counter-arguments, and providing evidence to support their case. And when it comes to nominal defendant, on the other hand, it's a party named in a legal case for technical or procedural reasons. That's where we see Illumina Inc. as the nominal defendant out here. And a nominal defendant may be added to a lawsuit to fulfill a legal prerequisite, such as ensuring that all necessary parties are properly named. This is done to prevent the case from being dismissed on technical grounds. Nominal defendants are not the primary focus of the legal action, and their role is essentially symbolic. In summary, the key difference is that a defendant is a central party against whom legal action or legal claims are directed and who actively participates in the case, while the nominal defendant is a party added for technical or procedural reasons and has a very minimal role in the case. Now, having said that, if we were to go and have a look at this document, it talks about the EU and FTC action. It provides a background of the entire Grail saga, and that's where we have the statement of the case. And there are a lot of redactions in here, and it traces the things that we have already spoken about, like the 476 million fine, and despite the fine, Illumina went ahead and acquired Grail. So it traces the whole saga out there, and it says that the board has voted to break the law, and it pins personal liability on the defendants and takes aim at 7 board members who are still on board, and seeks their removal, apart from the recovery of damages to Illumina and its shareholders and the cost due to the breach of the fiduciary responsibility of these directors. And the suit provides a brief background of Grail launch and spin-off and reacquisition, punctuated by antitrust action. It further alleges that the defendants defiantly voted to close Grail acquisition despite 10% penalty on annual revenue. So it's a rundown of things that we have already discussed before, but there are a lot of redactions out here, so I don't know what's there in the redacted area. But as I mentioned, it has got the plaintiffs as Carl Icahn's company, Icahn Partners, and they have a subsidiary of Carl Icahn, which is Matsumura Fishwork, which has got 100 shares since February 13, 2023. It's also a co-plaintiff. And the nominal defendant, Illumina, has been described out here. And now we come to the defendants, where it specifically talks about Francis D'Souza, who was company's president from 2013 and chief executive officer from 2016 until his resignation earlier this year. Defendant D'Souza was a member of the board beginning January 2014. Defendant D'Souza spearheaded the Grail acquisition and made and or approved misleading disclosures concerning the Grail acquisition in the company's security filings, including in the 2023 proxy findings defined below. Defendant D'Souza was further conflicted by his financial interests arising from his ties with and or domination of his co-defendants. In Q1 2022, after the Grail acquisition and resulting public controversy, Defendant D'Souza received a special grant of stock options from the board's compensation committee, comprised of defendants Caroline Dorsa, Robert Epstein, and Gary Guthart, to help ensure his retention and focus on innovation and increasing shareholder value. This special grant contributed to $25 million in long-term equity compensation that defendant D'Souza received from the company in 2022, in addition to his base salary of $1.1 million. All told, the company paid defendant D'Souza $52 million for his services as CEO for fiscal years 2020 to 2022, and a time period in which Defendant D'Souza oversaw a decline in the company's market capitalization of almost $57 billion. Defendant John Thompson was a member of the board from May 2017 and the chairman of the board from May 26, 2021. So it goes on to talk about each of the defendants apart from D'Souza, and gives an idea of what they were earning from the board, to set a background of what kind of benefits they got from Illumina. So it covers all the defendants out here. And there are some redacted portions here and there. But it then describes Grail, and it describes Illumina Venture, it describes Arch Ventures, and Helix Holdings, which was a promoter, Jay Flatley, who was the former CEO and executive chairman. So it describes his background and how he bought D'Souza into the company, and then he resigned as chairman of the board, and 3 months after that, the entire Grail saga began. And it also talks about Jacob Thiessen, who is the latest CEO and member of the board, appointed post-fact. And now we come to the factual allegations. It goes on to say in the allegations that Chair Thompson was not independent of D'Souza, and it takes aim at D'Souza and says that he made or approved misleading disclosures regarding the Grail acquisition in the company's securities filing and was conflicted by his financial interest arising from his ties with his co-defendants. And that's where we go to page number 12, where there is a full description of what D'Souza did. This is what I had read out to you. And with regard to Chair Thompson, it says that he was not independent of D'Souza. And then we go on to page 19, where you will see the factual allegations that have been given. And out here, it traces the fall of Illumina stock price from $526 dollars by more than 70%, and yet D'Souza was unfazed. So it quotes this one analyst out here, which says, one analyst described the deal's fallout as a carnage, saying, some CEOs would have folded, not D'Souza. He has pulled his shareholders into a years-long fight, and he failed to telegraph either the risks or duration. It has been an expensive undertaking. So there are some quotes from analysts also added in here for good effects. Then it cites Article 14 of the EU Merger Regulation Act. And there it is very clearly said, under our rules, companies have to wait for the Commission's clearance before implementing deals that are subject to our review. The standstill obligation is a cornerstone of our ex-ante merger control regime, which aims to preventing harmful effects to competition while our review is ongoing. This is the first time companies openly implemented their deal while we are carrying out an in-depth investigation. Today, we send our objection to the companies, informing them of the measures we intend to take to prevent the potentially detrimental impact of the transaction on the competitive structure of the market. So basically they are laying the foundation here that what the law is and how Illumina had run roughshod over the law allegedly, and they are also saying they are also showing that even EU felt the same. So that's why they have produced this section here, in my opinion. And we go on to page 36. Well, there are a lot of redactions here. So in 36, the suit quotes an article that says loss is inevitable in divesting Grail. So it says here, while the company has not disclosed an exact dollar figure for the additional costs incurred as a result of holding Grail under the EC's hold separate order, those costs likely far exceed $2 billion. See Hammond, Illumina, CEO Grail's hunt runs into a quagmire. That's the headline. And in that it says, in that article it says, Illumina is still unable to integrate a deal it ostensibly closed in 2021. It's spending about $700 million a year to keep it running in limbo. If it is forced to divest Grail, there is no obvious path where it doesn't take a loss on the billions it paid for it. These are not minor issues even for a company of Illumina's size. So there is another quote from another article that has been presented here, and it says defendants have caused Illumina to challenge the EC's determinations at every turn, appealing the EC's assertion of jurisdiction to review the Grail acquisition, appealing the EC's formal prohibition of Grail acquisition, and appealing the EC's imposition of the interim measures, including the hold separate order. EU General Court case numbers T277/21, T755/21, T709/22, T-5/23, and T-591/23. EU Court of Justice case number 6-611/22P. Not one of these challenges has succeeded. The company continues to appeal each of these determinations. So it shows it tries to demonstrate the pig-headedness with which the Grail acquisition was pursued. I would like to read you point 78 of this suit, which says, in January 2023, Illumina renewed a $750 million loan from Bank of America. The 5-year revolving credit facility included a change of control provision that triggers an event of default if a majority of the board is removed or replaced in any 2-year period without approval of the incumbent board. Such proxy put provisions are recognized entrenchment devices due to their chilling effect on proxy challenges. The Bank of America loan was disclosed in a 8K filing on January 4, 2023, but the change of control provision is buried in the 156-page agreement without comment. So these are the kind of poison pill like clauses that the document points out. Which was incorporated in another area, which was the Bank of America loan. And the suit explains why a class action is superior in this case. So let's go to the suit request, what they are demanding, because every suit has to say what exactly they want to have. So we'll scroll down. So here is what the suit is requesting. It says declaring count 1 of this action to be a class action and certifying plaintiffs as the class representatives and plaintiffs counsel as class counsel. So they want to aggregate all aggrieved parties together so that it's a coordinated effort rather than a piecemeal effort here and there. And declaring that defendants breached their fiduciary duties of disclosure in connection with the 2023 proxy filings, and ordering the conflicted directors on behalf of the company to issue supplemental and corrective disclosures to the 2023 proxy filings, including but not limited to disclosing full and complete material information on the following topics: all material facts concerning defendant's decision to close the Grail acquisition, including the undisclosed matters, all material facts concerning Illumina's tax basis in Grail, and all material facts concerning the financial interest of Illumina's directors and officers in Grail, whether direct or indirect. Declaring counts 2 and 3 of this action to be properly maintainable as a derivative action on behalf of the company, including by declaring demand to be excused. Declaring the defendants breach their fiduciary duties of care, loyalty, good faith, and candor as alleged herein, including for the purpose of facilitating an application pursuant to Section 225C, removing the conflicted directors from the board. There are still 7 conflicted directors, so it takes aim at them. Declaring the defendants' breaches of fiduciary duties are ongoing, awarding the company's damages awarding the company damages on count 2 and 3 in an amount to be determined at trial, but not less than 476 million in respect of the EC regulatory fine, all costs associated with supporting GRAIL under the EC's hold separate order, all costs associated with complying with the EC divestiture order, and all legal costs incurred after August 18, 2021 in connection with GRAIL acquisition related proceedings in the EU and the US, declaring the 2023 re-election of each conflicted director to the board to be void, removing the conflicted directors as directors as a consequence for their breach of fiduciary duties, or in the alternative, ordering the company to hold a special stockholder meeting to elect new directors, ordering the case consolidated with one or more class actions and or shareholder derivative actions to the extent necessary and appropriate to ensure that all of the harm complained of herein is redressed, awarding plaintiffs the cost and disbursement of this action, including reasonable attorneys and expert fees and expenses, and granting other such relief as the court may deem just and proper. So this is a very, very strong lawsuit. And they do not call Carl Icahn an activist investor for nothing. I think he is speaking on behalf of a whole range of stockholders who may not have the time or the sophistication to understand what exactly happened in there. So we'll look forward to more information coming out regarding this case, and I'll bring it to you the way I understand it. So you could also go and look at this document. It's in Bloomberg Law. You can check it out. The whole text is out there. I'm not a lawyer, but I've tried to understand as much as possible and brought it out to you. Hope you enjoyed this segment, and I hope it gives you an idea of what is happening with the shares of Illumina that you're holding in your portfolio. And you could take an informed decision going forward by consulting with your financial planner or financial advisor, and also doing your own research further into this matter. With that, I would like to bring this video to an end. I'll catch up with you again in the next video. Bye for now.